parties, when they are trying to enter into an arbitration clause, they do not apply much of their time, and they do not apply much brains to it, because they think that it's just an arbitration clause. Sometimes some of the PSUs I've seen have a habit of copying pasting their own formats. And today, when we see that some of the arbitration clauses actually refer to Arbitration Act 1940,
Yeah.
which shows that it was no application of mind, and merely it was copied pasted. Same formats were being followed, and they didn't realize perhaps that 1940 Act was repealed long back when the 1996 Act came into the picture. And some of them do not even address to the amendments. Now there have been more amendments after 1996 Act. The first amendment was 2015, then there was in 2019, and now there's a 2020 amendment.
Mm.
Having said that, what I'm trying to make you understand is that parties must realize that you need a lawyer or somebody who knows how to draft an arbitration clause, and you need to pay attention to it, because it may look like just a 4-liner or a 5-liner, but the cost and time which it can consume, and inartistic drafting of an arbitration clause can create blunders and can actually cost you a lot of money and the time consuming.
Mm.
I have seen that if it's a poorly drafted arbitration clause, especially in our country, I've seen that the respondent mostly wants to resist arbitration. And if you have a poor arbitration clause, it is actually going to make it easier for the respondent to resist arbitration. And what are these common objections that they take? Sometimes they say that there is no valid arbitration clause as it lacks the prerequisites of a valid arbitration clause under Section 7. Sometimes they say that I never agreed for this. It's obtained on fraud. Some of the other common objections would be perhaps that the language of the arbitration clause is such which says that courts will have the jurisdiction and not the arbitrator. So, some of the arbitration clauses are really, really absurd. They are, it's called inartistic. You may call it pathological. You may call it unconscionable. You can call it anything you like.
Yes.
You have different terms for that. But in a lot of cases, sometimes arbitration clause itself becomes the issue and dispute in itself. Forget about the main dispute. And I have seen that happening.
Yes.
A lot of money, energy, time is lost to give it a true meaning. For instance, today only I was speaking to somebody, and somebody said an arbitration clause which gives choice to parties to approach different institutions. It was very loosely worded.
Mm.
And now what will happen if you choose one, the other side will say, no, you can't approach this institution. So, there is no clarity in a lot of arbitration clauses. Sometimes what we have seen is the act would not refer to the amendment, and then the parties want the amendment to apply. And then they go to the court and they say that, look, arbitration amendment should apply. The other side say, no, it should not, because you have not used the word amended act will apply. In some cases, who will appoint the arbitrator becomes an issue, the way it is worded, and what kind of disputes can be referred, whether connected disputes to an agreement can be referred to arbitration. All of these are very common objections that I have seen, and I'm witnessing day and night. So today I'm going to discuss few tips which I think you all can keep in mind to avoid the blunder as much as you can. And unfortunately, there cannot be a straitjacket formula for valid arbitration clause. I cannot tell you today that, look, this is the perfect arbitration clause and you should use it in all your agreements.
Correct.
So parties decide their arbitration clause based on their needs and as per the contract. We have to customize it as per our requirements, and we have to make it look as per our needs. Now, I'll tell you what are the key elements that we have to keep in mind when we have to draft an arbitration clause. And I'd like to first quote a judgment of Justice, I think it's a Visa International case, which is a very famous one. I think it must be there in the note which I have provided. I'll read it out for you. The Supreme Court said that no party can be allowed to take advantage of inartistic drafting of an arbitration clause in any agreement, as long as clear intention of the parties to go for arbitration in case of any future disputes is evident, and material on record, including surrounding circumstances. So what the Supreme Court felt that, look, merely because an arbitration clause is poorly worded, you really cannot take advantage of it and you cannot wriggle out of your obligation to arbitrate. And then, it's not open for you to make these kind of excuses that there's no valid arbitration clause, and don't make excuses to get rid out of it. So, I mean, this happened because Supreme Court realized it's a major issue, and parties are actually delaying the proceedings and making arbitration even worse than litigation in terms of delay. So, probably that was the need why Supreme Court clarified this. Now, I'll give you two examples. I think in the PPT also there are two examples of pathetic, probably really inartistic. I have taken the worst examples. I'm sure there may not be some of the arbitration clauses which would be like that. So one is that all disputes arising out of the present contract shall be settled by way of arbitration. Now, to a layman, to a common man, this may seem to be a perfect arbitration clause. That the intention is clear, that if disputes will arise, we will go for arbitration. But the problem is that this arbitration clause do not have the prerequisites or the essential elements of an arbitration clause. So merely on the basis of this arbitration clause, you cannot really know who is going to appoint the arbitrator, what would be the language of the arbitration, and how many arbitrators are going to be appointed, what is the seat of arbitration, which law is applicable to the arbitration. None of that has been answered. Merely, it has been mentioned that disputes will be resolved by arbitration.
Yes.
I think now, if you look at it like that, if you try to give it a true meaning, it is next to impossible to ascertain as to how to get answers to these questions.
Yeah.
Now look at the other one, which has very nicely been put in the PPT. Okay. So this is a relatively detailed arbitration clause, but look at how interestingly, some blanks have been left. So this says, any controversy under this contract shall be referred to arbitration under the rules of dash. Parties will mutually decide the arbitration, and in case of disagreement, the arbitrators chosen by the parties. It is argued that the dispute shall be submitted to the Court of Delhi. It should be agreed anyway. I know sometimes the English can also be like that in arbitration clause. So I told you this is the worst example.
Yeah.
So if you look at this arbitration clause, the problem is firstly, we don't know which rules the clause is referring to. It's now to get the idea to this, I think this will take forever to ascertain what was the intention of the parties. And if you read further, it is talking about disagreement between the arbitrators. Now, what will happen if there is a disagreement? Initially, it says mutually decide the arbitrator, and in case of disagreement, I don't know. This doesn't make sense. And if you look at the last and the most interesting blunder, it is dispute shall be submitted to the Court of Delhi. Now, since the very beginning, I could understand that they're talking about some arbitration to happen to resolve the disputes. All of a sudden, they're talking about the courts of Delhi. So it is not clear whether they want arbitration or they want to go to the court of law. So another reason for another party, whoever wants to resist the arbitration, to say that, look, the intention was not to arbitrate. The intention was to go to the court. So I think that it's extraordinarily important for parties to know how not to draft an arbitration clause rather than knowing how to draft an arbitration clause, because I mean, these blunders have to be avoided. And these are some blunders which can actually, delay the arbitration proceedings to such extent that the parties will eventually be disappointed and will be left frustrated.